Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're talking about a shareholders dispute of some complexity. What we have today is a plaintiff coming before the court seeking orders pursuant to Section 175 of the Corporations Act to amend the share register of a company to include themselves, listing themselves as shareholders. Let's try to pick it apart and see if we can understand it together. Let's jump back in time. In the early 1990s, we have a parent, and that parent creates a will, and what that parent says is that 3 of my children are to inherit my estate in equal shares. Let's flash forward to 2016. That parent passes away, and one of the 3 siblings, one of the 3 children, we're going to call them the first defendant, is named as the executor in the will and seeks a grant of probate and is granted that grant of probate in respect of the parent's estate. And so defendant 1 becomes the executor of the estate. Now, the estate includes a number of things. It includes a piece of real property in a Sydney suburb called Concord. It includes shares in a number of different companies. And what happens is that in or around or slightly before 2018, ownership of the relevant real property in Concord passes into the hands of each of the 3 siblings, and so they become co-owners of that property. There's some dispute there, and today's plaintiff, who is one of the siblings, the plaintiff sibling, commences proceedings pursuant to Section 66G of the Conveyancing Act. And essentially what proceedings of that kind are all about. They're all about seeking an independent trustee to sell a piece of land that you and I own together and we're not getting along, so we need someone independent to come in. They're the 2018 proceedings that today's plaintiff brings to sort of criticise a bit the brother, the way he's administering the estate, the way the executor is administering the estate, and to seek these 66G orders. Now, what happens is those proceedings are settled, and there are orders made by consent, and shortly after that, ownership of the property changes hands. And so today's plaintiff, having brought those 2018 proceedings, ends up dealing with the issue regarding the real property. But you'll recall that today's application, a piece of litigation commenced in 2024, is about shares. These are shares that formed part of parent's estate, so were transferred into the hands of the first defendant, the executor of the estate, and that the plaintiff now says, amend the share register so that I am listed as an owner of some of these shares pursuant to the terms of the relevant will. Now, the defendant resists this application, this Section 175 application, and resists on a number of bases, but the fundamental basis is what you and I and some lawyers might call an shun estoppel. An an shun estoppel is sort of a breed of legal right or equitable right, similar to res judicata or issue estoppel, that sort of says you can't have 2 bites of the cherry. You know, you sued me about something in the past, you can't sue me about it again now in the present. And this is essentially the argument raised by the brother. So let's dive into the facts a little bit more to see if we can understand how an argument of this kind might come up. Now, remember, we have parent passing away in 2016. We have the 2018 proceedings about this piece of real property in Concord that sort of settled. And at around the time of the 2018 proceedings, the executor's lawyers had made representations of, oh yes, the share transfer is going to happen. And based on the correspondence exchanged at the time, it seemed supremely likely that the share transfer was what we might think of as a procedural issue. It was going to be part of the administration of the estate, and it was more or less accepted between all parties that it was going to happen. And so we have this kind of correspondence being exchanged. And as you might imagine, because there's a piece of litigation going on, there are other issues ventilated in that correspondence. But in essence, there's some acceptance in or around 2018 of the share transfer going ahead. What the defendant, the first defendant being the executor, says is that over time and in some way, the plaintiff had indicated that no, the only thing they were looking for from the parent's estate was some entitlement on the basis of this real property, and that they had said or had indicated in some way that having obtained the entitlement in relation to the real property, they weren't looking to press any other claims in relation to any other estate property. Essentially, get the Concord house dealt with, and that's it, was the executor's view on what they said the plaintiff sibling had in relation to the property. Plaintiff obviously disagreed with that. And so the plaintiff is pressing this claim, the defendant is raising, among other defences, the defence of and shun estoppel. Now, and shun estoppel is reasonably technical. It is about whether an issue that could have been brought in an earlier piece of proceedings, in fact, should have been brought. And so the mere fact that you could have done something back when you brought your different proceedings doesn't necessarily mean that you should have, right? There's a question of, was it unreasonable for you to withhold this issue, for you to keep it up your sleeve? Is there something improper about you failing to bring it in the earlier proceedings? This is the argument that the defendant has to succeed on if they're raising this point of and shun estoppel. Now, let's spoil the ending, or get to the ending. The court finds that the first defendant's and shun estoppel defence fails, and it fails for a number of reasons. Reason one is that the 2018 proceedings, while they were sort of broadly concerned with the parents' estate, by the time the 2018 proceedings were commenced, the ownership of the land had been transferred into the hands of each of the three siblings. So the dispute, while it had the estate in the background of its chronology, was actually really a dispute between three co-owners, three contemporary co-owners at about the same time. And so it wasn't an estate dispute so much as it was a co-ownership dispute because the property had changed hands. Now, secondly, and this was fairly operative, with great respect, it struck me on reading the judgment, there was the element that at the time the 2018 proceedings were commenced, the correspondence exchange between the solicitors pretty much promised or showed that the share transfer was going to go ahead. So at the time the 2018 proceedings were running, there had been letters exchanged, including letters from the first defendant's solicitor saying, yeah, share transfer, it'll be going ahead. And so in those circumstances, what reason could there have been for the plaintiff seeking orders in relation to the transfer of the shares? And arguably, if they'd thrown in orders about the shares in that set of proceedings, that might have itself caused separate delays, separate issues to arise. Thirdly, what the court said was essentially that the duties of an executor are pretty solemn and pretty important, and we don't really want to lightly go about protecting those executors and finding that an and shun estoppel has arisen in circumstances where that may be against the public interest in trying to hold executors to distribute the contents of an estate in accordance with the will in respect of which they've obtained the grant of probate for, if that grammar works. I hope that makes sense. I hope that assisted you, and I'll just confirm that similar arguments were raised in relation to the defendant's abuse of process defence, which failed on similar grounds. The delayed defence that the defendant raised also failed on the basis that they weren't really able to point to any prejudice that they'd suffered in relation to the gap in time between 2018 and 2024. And as you might imagine, the plaintiff would not have been particularly impressed by a delay argument, because they might say, well, we're complaining about your delay in relation to the administration of the estate. Hope that discussion assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note. Cheers.